Hey, hi. Today I just want to share with you a law article about delivery of vacant possessions for purchasers, especially when a purchaser buy a property from a developer and there is a delay. Actually, here in this kind of property sale and purchase agreement, whenever there's a delay, there are a couple of issues that we need to look at, which I will split them into different videos. The first is how you calculate the late payment interest or the liquidated damages payment that is due by the developer to the purchaser. And then the second one is you probably need to understand when does time start to run and when does time ends. So because if you need to calculate, you probably need to calculate the starting time and the ending time. Generally speaking, it's from the day you sign the SMP or the booking form. Of course, there are case law that says that it should start earlier from the booking form. And when does it end? You will probably need to look at this clause, that the developer shall let the purchaser into possession upon the issuance of certificate of completion and with water and electricity supply ready for connection to the building. So this is another second point that I think I will do in a separate video with analysis of the case law. Then the third point I think which I wanted to highlight in this video is about the uh, extension of time sometimes applied by the developer to get waiver so that they don't have to comply with uh, this clause 24. This is actually Schedule G. There is the for landed properties. There is a Schedule H as well for apartments, Soho, and all that, which is not 24 months, which is usually 36 or 48 months. Some even have 54 months. So sometimes, especially during this COVID period and all that, right? So they are not able to developer are not able to complete within the 36 or 48 or 54. So technically speaking, based on law, the sale and purchase agreement terms, they will need to pay for the liquidated damages, usually computed at 10% of the purchase price, uh, based on to be calculated daily. From the day they are supposed to deliver to you, which is 48 months and 1 day onwards, until the day they actually deliver the property to you. So it can be another 150 days delay or 340 days delay. It all depends. So I just want to show you the latest clause, the latest case law that talks about the extension of time. Um, okay, second. The latest case law, of course, is about the differentiation between the meaning of the minister and also the controller of the housing ministry. Housing controller is appointed by the housing and local government ministry, and so in this case, basically, there are two important cases here. One is Ang Ming Lee, which is a federal court case, and then there's another one called the Blue Dream City Developments in Rambahar versus Alvin Leong, which is a court of appeal case. Um, I will basically start with the federal court case first. It says actually um, the the controller will where who granted and issue out this extension of time. This federal court held that it's invalid and ultra virus. Ultra virus means outside the powers of the housing development controller or the ministry's power. So, meaning that the developer or the housing ministry are not allowed to vary the agreement unilaterally, i.e., extending the time, because the purchaser also suffer from all these delays. They have to pay for their housing loans and all that. Then, of course, provided that basically it satisfied owing to special circumstances and hardship and necessity, compliance with any provision of the contract of sale is impracticable and unnecessary, modify and waive and in writing of such provisions. So it was held ultra virus, the HDA. So basically, this is a case that is good for purchaser. Uh, and then, of course, Blue Dream distinguishes unwillingly. They say that applied for. I think I will just ignore the first EOT because the first EOT was applied before the signing of the SMP by the purchaser. So I think they have every right to get extension before they even sign or contractually bound with the purchaser. But the second one, which is important, because it was due to some external issue or stop work order, which is not the fault of the purchaser, and then 17 months, and then the controller allowed, of course, in this case, it allowed partial EOT for 12 months instead of 17 months for the existing unsold units. In respect of sold units, the condition of 12-month extension was a requirement that developer enter into supplemental to the purchase. They require mutual consent. So of course the purchaser didn't agree to the mutual consent. And then of course this case started off with the housing ministry and the developer first, and then after taking into account relevant considerations, Mr. himself signed a letter of extension, extend the time for developer to complete the project. Then of course the purchaser contested decision by granted on the second EOT by way of judicial review. Judicial review is a court procedure. Whenever there is you want to challenge a government department's decision, you can't really sue them like a plaintiff defendant kind of scenario. So you have to do an application by way of judicial review, where the High Court judge will do the make the decision whether to override the government's decision. So High Court in this case allow the judicial review and declare that again second EOT was minister was illegal, and they appeal to Court of Appeal. This is the one that I think is most important. They distinguish mainly with the current case, and basically they say that the minister has no power to vary, but rather the court rule and minister cannot delegate the power and modify the SMP prescribed by the HDA. Hence, FC ruling argument cannot be construed and stretched to mean that the regulation 11.3 is ultra virus. So the COA Court of Appeal further remarked that minister could not lose the power he validly possessed by delegating the power to the controller, even if the regulation delegating the power was deemed to be ultra virus. So the minister still retains the power to grant extension because this power is conferred by the parliament. So take note. I'll just put some of the links here for you so that you can actually look them up. Wait, let me see. This is another case, but this one is a little bit outdated. It was dated in 2018, which is during the Ang Ming Lee's situation. And to see whether this is the clause on the delivery of the vacant possession, and this is the clause on manner of delivery of vacant possession. They are two different clauses, but they are to be read together. So let's see what else I think is important. This is just time start to run. Yeah. KPKT, this is the department for the housing ministry for any aggrieved purchaser if they want to do any reports on any defects claim or any late delivery claims that they want to do, or any other types of claims. This is one of the ruling that was in favor of purchaser. That was way back then, but there has been many changes since 2019. And yeah, that's all for today. Thank you very much.